morning, and thank you for standing by. All lines will be in listen-only throughout the entire call. If at any time you do have a question, you may press star, then 1. Today's call is being recorded. If you have any objections, you may disconnect at this time. Ms. Bingo, you may now begin.
Hi, welcome to today's webinar. Very happy to have you with us this morning because we're going to have a webinar with a practitioner in Beijing, Rachel Tan. She's a consultant at Rouse and head of their trademarks group there in Beijing. Rachel's going to be talking to us about fundamentals of trademark registrations in China, and she has considerable experience. She focuses on brand clearance, protection, and enforcement in China. She speaks Chinese, excellent English, as you will be able to hear, being a native speaker that she is, and we're really happy that she's here. If you have any questions, Rachel's very happy to have you call into the operator and take questions in the middle of her presentation, so it's more of a dialogue with her. China is a first-to-file system, and there may be some differences from what you're used to in the U.S., so please ask Rachel. She's the expert. Rachel?
Okay, thank you, Janice. Well, firstly, thanks a lot for giving me this opportunity to talk to all of you. Thanks to the lovely operator who has managed to cure me of my complete technological Ludditeness. And good morning to all of you. Hope you all had your morning cups of coffee and are ready to go. Looking at the first slide, I'm going to just talk about the top 10 on brand protection in China. And because I had actually more things to say than just 10, a few other helpful tips as well. I suppose a lot of you been to China or know something about China, but if you just bear with me, I'll just like to set the stage on a real background of the IP in China. Now, in my first slide, just really a brief introduction to China, which everyone knows about. It has a massive population of 1.3 billion, and just last year, it's overtaken Japan as being the second largest GDP behind the U.S. In China, Beijing is the political, cultural, and academic capital. Shanghai is where finance is, and Guangzhou is where all the manufacturing capital is based. So most people who come in to manufacture goods and products in China normally have their factories in Guangzhou, which is in southern China. And again, just to remind all of you, if you want to just chip in with questions, I'll be very happy to take them. Now, my next slide is just a picture of the whole of China. As you can see, there are a large number of provinces, administrative regions, and it's really fairly spread out. You can see a lot of regions actually do specialize in manufacturing certain products. For example, as I said, Guangzhou does a lot of manufacturing of many kinds of products, including pharmaceuticals. Fujian, Zhejiang, they do shoes and things like that. So it really is spread out all over China. The next slide has a picture of the ex-president Jiang Zemin handing over the reins to the current president, Hu Jintao. And what I'd like to focus on is in Hu Jintao's term as president, what is his driving factor? And his legacy, we believe, is to actually develop China from just being a manufacturing-based society into an independent innovator of its own technology, its own brands, its own patents, its own designs, and that has really been the driving force in the last 10 years. I'm not sure whether any of you know that China has plans its economy in like 5-year plans, and the last 5-year plan was actually just ratified yesterday, where the National People's Congress gathered in Beijing to discuss what are going to be the goals for China in the next 5 years. Now, out of that, innovation is still on the top of the agenda, and as part of that, the hope to actually grow the domestic market so that China will be less dependent on exporting, but actually more on its internal domestic market. And this plan for innovation is not a new thing. It actually was in the last 5-year plan, which was announced in 2006. And as you can see from my slide, once China decides on something, they put the whole Chinese machinery and mechanics behind it. In 2006, they had the State Council for Science and Technology. 2008, there was a wide national IP strategy. in 2009 and 10, we saw a raft of opinions, amendments to the IP laws, especially 2009, there was amendment to the patent law. And right now, there's discussions of amending the trademark law. So as you can see, IP really is very high up in the agenda. In the next slide, just like to give you an overview about the situation of IP for the last year. We noticed that in China there actually is the most trademark and patent filings in the world. In 2009, there were 830,000 trademark applications just filed in 1 year. But as part of that, unfortunately, there are also many bad faith trademark applications and really junk patents, worthless patents. So probably the next step for China is really to come up with really proper innovation technology than just merely filing for the sake of getting something on the register. Another interesting point is that China has the most IP civil litigation in the world. And interesting fact is that 90% of these civil litigation actions are actually between two Chinese companies, and the remaining 10% are between a foreign company and a local company. And civil litigation is quite a useful tool against really legitimate companies out there, although the trouble of enforcing a judgment is still very difficult. In terms of administrative enforcement, and what we mean by that is having local authorities in each province help you enforce your trademark rights against infringers. That is still very routine, and the success rate really is dependent. In some provinces, the administrative enforcement is really very good. In others, there's a lot of protectionism, so it varies from province to province. And what we also have seen in the last few years is that the counterfeit market, it's no longer, just a factory to produce counterfeits, you can go there and shut them down. It's become this real web of deceit where there's multi-layers. The counterfeiters are very sophisticated. They use a lot of technology. And not only that, they're moving away from actually straight counterfeits into more lookalikes. So basically, you have the lookalike of your product, but they will change the trademark. And that really makes enforcement very difficult. What is encouraging is that the Chinese government wants to have IP protection, has put a lot of manpower behind it. But on the flip side, again, how effective it varies from province to province. And, they have also tried to put in place certain measures that gives an advantage to their domestic companies as opposed to foreign companies. Another point is that we're seeing enforcement procedures being more effective as trade fairs. And as you know, in China, there's almost one trade fair every week for any conceivable product, it's being sold around the world. And in certain provinces, the local enforcement authorities have put in place better procedures to try and combat infringers during trade fairs. So this is generally what we've seen. And I guess what I'd like to say is that in terms of IP, we like to take a holistic approach to IP in terms of brand and a complete brand image of a company. I think just last week I had quite an interesting conversation with a lot of European small medium enterprises and finding out really quite different views about what they thought. In terms of some German companies, we felt that German companies were pretty progressive in the sense that SMEs are the backbone of a lot of Germany, and they're very heavily invested in manufacturing. And we see a lot of them actually protecting all their IP, trademarks, but as well as other forms of IP, pretty effectively in China. And there are some other European SMEs that I've talked to who still feels that China is like some bandit country in the 1990s where there's no IP, and there's some total brand protection is one trademark for our main brand, and that's good enough. Well, I think for any foreign business that really wants to invest and have a long-term goal in China, that we can't just say one trademark for one brand is enough. Really need to take a complete look and spend effort and time investing in IP in China, because the opportunity here is too great, and there are ways to engage with the IP system so that you can obtain the best protection. I mean, I'll be honest, it's not the easiest place, but then there are IP laws, and using it, I mean, most companies can actually develop a portfolio of protection for its rights in China. So that's really painting the general background and landscape about China. Again, I'm happy to take any questions at this stage.
Once again, to ask a question, to press star, then 1.
All right. If not, I'll just move into the meat of my discussion, which will be what I call Rachel's top 10 on IP protection in China, with the main focus on trademarks. So number 1 on my list is look before you leap. And basically, if you want to sell goods, manufacture or sell goods bearing any trademarks in China, the first thing to do is to ensure whether your trademark rights conflict with any prior registered rights which already exist on the register. I think most of you know that trademark rights are territorial, so that a right in one country, for example the US, does not necessarily give you rights in any other country except in very limited circumstances where your mark is extremely well known. And when we're talking about extremely well known, we're talking about the Coca-Colas of this world. Okay. Another reason why you should check before you start launching your product is that you may discover that a trademark pirate has already registered your trademark and will use it against you, or at least try to sell it to you for an exorbitant price. I mean, we have to admit that one of the biggest problems in China are bad faith filings. There are a lot of people out there who just go around the world, go read the internet, read the newspapers, look for any new brands, any big brand overseas, and start registering in China. And then when the legitimate trademark owner comes into the market, it finds out its mark has already been taken. And by that time, it is really difficult because while there are laws that you can use to try and get rid of the mark, it is not easy, and it takes a number of years to do so. And, you can't keep your product from being launched for that period of time. So it is really, this actually brings me to my next topic, which is point number 2, which is file, or someone else will do it for you. As Janice mentioned, China is a first-to-file system whereby trademark rights are acquired through registration, rather than use. I know all of you in the U.S. are a common law country where use of a mark, prior use, gives you certain rights. But in China, that argument normally is very, very hard to use, and registration gives you the rights. So I can't emphasize, any more than just to say file as early as you can. Another point is intent to use is not a requirement in China. So unlike in the U.S., you don't have to fill up a declaration of use or intention to use the mark, which is also the reason why there are so many trademark pirates, because no one needs intent to use. They can just file the mark. So long as there's no prior conflicting mark, it usually will swim through to registration. Another point under this is that in China, multi-class applications are not available. As you know, that worldwide there's a niche classification where goods and services are divided into different classes. In the U.S., which is a multi-class application, you can file for, let's say, Class 9 for computers, and at the same time file for Class 42, which is computer services. But in China, you would have to file individual applications for each class of good you want to protect. Another point is that Hong Kong and Macau are not covered under the Chinese registration system. Hong Kong and Macau are part of China, but they are still considered special administrative regions. They have their own laws there, which are actually very different from the laws in China. So you would have to obtain protection there separately.
Excuse me, we do have a question from Ralston Houghton. Your line is now open.
Yes. I am a recording company and a DVD distribution company. CDs which involve music, intellectual properties. I understand that they also would pirate the registration marks or trademarks. In regards to the music, because of the new technology with downloading, what type of piracy would they do regarding this? And how can we deal with this matter?
Okay, if I may just repeat your question.
Yes.
Are you talking more about the copyright in the music and artistic work as opposed to, or are you talking about the trademarks which actually
copyright
appear? The copyright. Okay, I think copyright probably is a separate issue which I will touch upon perhaps later at the end of my talk.
Yes.
Because mainly I'm talking more about trademark protection in China.
Right.
There is a procedure for copyright recorder in China, and
yes.
I think I have to admit that copyright in China is a very weak right, and there is a certain lack of enthusiasm in really enforcing it. If you go down the streets of China in very legitimate buildings and shopping centers and malls, you will see
yes.
shops selling pirated DVD as though it were a normal shop. So I do have to admit that copyright is not the easiest. I mean, there are laws for it, but there's very little interest in really enforcing copyright. And perhaps, part of it will be helpful to actually also, support the lobby groups such as the MPAA and all the other industry groups which are actually pushing for further enforcement. So there is copyright recorder available. As to enforcing it, you would have to spend quite a lot to do it because there is a certain lack of interest in enforcing copyright as much as there is in trademark and patent rights. Is
yes.
that helpful?
Yes.
Okay. Do I have any other questions?
I guess you have answered. I was just a bit curious about the protection of the downloading also, the digital download from off the internet. Is there any type of protection for regarding the copyright or regarding the downloading, the digital content?
Yeah, I think it really would be the same. If it's copyrightable, then it would be protectable under
yes.
copyright. But then again, enforcing it is not the easiest thing to do. So,
okay.
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 All right. Okay.
So, the best thing for us to do then is to register these music or contents.
Well, you can register your music content as copyright, as I say, and that will give you at least some form of registration certificate to wave at the bad guys. And
okay.
also there are websites which you can write to the internet service providers,
yes.
and some of them, if there are clearly infringing material there, you can write to them and ask them for it to be taken down. So there are
okay.
steps. But, I really appreciate your question, but we might be straying a bit from the topic today. So maybe I can pull it back to trademark and brand protection. But thank you very much. It's very
okay. Thank you very much, Jude. Thank you very much.
This is Janice. I'm just going to interject here. Actually, one of Rachel's colleagues, Tim Smith, did a presentation on digital piracy in China that may be of interest to the caller, and that is on the May 7th, 2009, on our stopfakes.gov website. So if you want to listen to Tim Smith's presentation, I think he would answer some of the questions that you would have on downloading music.
Okay. May 7th.
Thank you.
May 7th, 2009.
2009. Okay, I got you. Yes?
We have an audio recording there.
Yes, okay. Yes.
Okay, fantastic. All right. Just going to move on to my number 3 point, which is file broadly, but beware the subclass system. Now, we have this little idiosyncrasy in China, which doesn't exist either in the States or in the European Union, and that is we have a subclass system. So as I mentioned, the needs classification is divided into 45 different classes of goods and services, mainly based on the nature or the functions of goods and services. And in China, they have actually created a subclass system, which is, in really looking at it, very artificial. And many times we scratch our head and thinking, how did they actually come up with this subclass system? So, for example, an example I've given of really an artificial distinction is that in class 25, which is the clothing class, most people overseas think that if they file an application for clothing, headwear, and footwear, they have the whole class 25 covered. But in China, no. In China, class 25 is actually divided into a great number of subclasses, such that if you had an application for clothing, it may be considered different to an application for swimsuits. And I notice in my practice a lot of practitioners getting, trapped into this kind of folly of not filing in the whole subclass and trying to rely on their rights for clothing to stop a later mark for swimsuits and failing, because certainly at the registry level, they're considered different. Also, in the local enforcement level, which are local low-ranking authorities in different provinces, they will possibly find it different as well, because what the local enforcement wants to do is that they want to enforce your mark for the exact good that is listed in your registration, and general terms like clothing and footwear may not be sufficient to cover something like swimsuits. Fortunately, the courts are looking at it a bit broader, and again, they will take into account the facts and circumstances of the case. But my advice is that because filing a registration costs a few $100s, if you can, just protect your mark for all the goods of interest, all the related goods for interest, and cover as many subclasses as you can. And the last point, again, is cross-class trademark protection is rare. So, again, maybe in the States, if you filed in class 9 for computer services or computer goods, it's probably easy to argue that something maybe in class 38, which is telecommunications, are related. But in China, again, the argument is sometimes really hard to make, and the courts at the registry are only more willing to grant you what we call cross-class protection if your mark can be proven to be well-known in China. And again, for a mark to be well-known in China, that's a very high and very stringent standards, and ironically, very few even of our global brands have actually made it to this well-known list of trademarks in China. So it goes back to my point, file broadly and beware the subclass system. Okay, moving on to my next point, that's number 4, Chinese trademarks and transliteration. A lot of foreign companies will come into the country with English marks or Roman marks, and very easily forget about the Chinese version. And that's pretty understandable, because if someone were to come in like Louis Vuitton or Prada, they would still market themselves as Louis Vuitton, Polo Ralph Lauren, Prada. It is very unlikely that they will market themselves that much really by the Chinese name. But nonetheless, if you don't come up with a Chinese version of your trademark, the public will, the media will, when they refer to you in newspaper, magazines, internet articles. We have quite a little funny case in point, whereby a company, Viagra, came in and they wanted to actually call the Chinese mark Wan Ai Ke. But before they did that, the Chinese public actually chose a name for Viagra, and they called it Weige, which actually means literally great brother. So the public started caught on that name. They loved that name. No one actually even cared about the official name. And so, as soon as you know it, a trademark pirate actually filed and applied for waiver and, managed to get that registered, and Viagra had to spend money opposing and stopping that mark. So again, when you come in, think of a Chinese version that will go down well with the public, and, file and register your Chinese trademark. And do try and spend time selecting a good transliteration. I think the example of Coca-Cola has come in with their mark Coca-Cola, which means the more you drink, the happier you become. So it's phonetically very similar to Coca-Cola, but also, the whole impression that the mark gives to the public is one that's really positive and will go down well with the public. Another point, which is really just a very technical point, is that when you file any applications in China, your company name will have to be transliterated in the application form. I mean, this is not a translation. It doesn't really have legal effect, but it can get really messy if every time you file an application with the different registries, you use a different transliteration. I think it might come when you're trying to enforce the mark. It might be just a bit confused when you have really different Chinese transliterations for your trademarks and company names. So be consistent. And don't only just be consistent in China, but also in all the Chinese-speaking jurisdictions, such as Hong Kong, Taiwan, Singapore, so that you actually have an overall consistent brand message in Chinese. Point number 5 is use your trademark correctly. Firstly, you should register the...
Excuse me, we do have a question from Mark.
Okay,
Cooper.
no problem.
Sir, your line is open.
No, I'll take my question at the end. I'm sorry, I didn't mean to press it that early. I'll wait.
Okay. I hope to hear from you later. Point number 5 is use your trademark correctly. Firstly, you should register the trademark you intend to use. So if you have a trademark that is just in plain capital letters, use it that way. If you have a trademark that actually has quite complicated stylization that gives a rather different impression, you should also register the trademark in that version. Why? Because if there's a regulation, the law that says that if you substantially alter the trademark, the registered trademark, you can actually be liable to a fine. So the mark you register should then also be the mark you use. Another thing to be careful about is that you can only use the R registered symbol with a registered mark in this country. So if you haven't registered a mark, you can put TM because that doesn't really have any legal effect, and that would just denote you're using it as trademark. But until your mark is registered, do not put R symbol because, again, you can be subject to an administrative fine. In China, likewise, a mark that you registered, you have to use it. And if you don't use it after 3 years from registration or after any consecutive 3 years, a third party could cancel your mark. Now, the good news is that unlike in other countries whereby you actually have to file declarations of use, in China, your mark stays there until someone cancels it. So in a way, it doesn't require any, you should use the mark and be mindful and be vulnerable, but it would take a third party to cancel your mark. Now, point 6 is a little practice point because, especially for countries that are all signatory to the Madrid Agreement or Madrid Protocol, a lot of companies may find using the international registration system more convenient. But there are a few practice points that come up from that. The thing is that when you use the international registration system, the goods you designate in your home country, for example, the U.S., would have to be the same goods you designate in China. So again, your protection could be pretty narrow because in China you would have to follow the same goods that you designate in the U.S., whereas if you were to file a Chinese registration, there's no intent to use, so you can file as broadly as you like. The second point is that even when an international registration is granted protection in China, you do need to obtain a localized certificate of registration in order to enforce the mark. And currently, this takes around 2 to 3 months. So even though since 1st of January, the WIPO, which is the body which administers the international registration system, is obliged to send all contracting parties a statement of grant of protection. This statement, unfortunately, is just in English and it's just a piece of paper. It doesn't have any official stamp. The local Chinese authorities will not give much regard to that piece of paper. They will need you to go to the Chinese Trademark Office to apply for a localized certificate. Okay. Moving on to my next point 7 is to help the Chinese authorities help you. I think, as I mentioned, China has IP laws in place. They have systems. But it is rather a self-help system. You need to get your own house in order before the authorities help you. It is a country with a lot of bureaucracy, so the easier you make it for the authorities, the easier that they will actually assist you in getting what you want. I think the first point here is to adhere to all formalities. In China, when you file any application before, the Trademark Office or other authorities, you will need a power of attorney. Sometimes a simply signed power of attorney is enough, but there are other times whereby you take action. For example, you want to assign a trademark, or you want to file an opposition against a later mark. You do need an original power of attorney together with just a copy of your certificate of registration from whatever country you are. And the time frames are pretty short. So, always try to have someone ready in hand to sign the powers and be prepared, to courier over to your attorneys in China. Another point is that evidence in China is really important. And again, China is a civil law system, not a common law system, meaning if you actually have to go to the registry or to the court, a lot of the decisions are made based on the quality, and how authentic documents are before the judge or the examiner. So evidence is very important, and sometimes this evidence either needs to be original or notarized and legalized. So you don't have that ability, like in the U.S., to have long discovery sessions whereby the lawyers can ask for evidence from the other party. In everything, in China, everything is actually front-loaded in the beginning. So, all your impressions of Boston legal, LA law just goes out of the window. There's not going to be that kind of evidence exchange and, meeting to court. I mean, both parties, lawyers, will have to bring all the evidence right before they file the claim, and then there will be the hearings, but all the evidence should be in place well before then. And again, evidence in China is most important. Your mark may be, having a great reputation in your home country. You may have evidence there. But ultimately, as trademark rights are territorial, evidence in China is the most important. Again, my next point is that if you really want to build a long-term brand in China, be prepared to invest a bit in enforcing your rights. The most basic will be to monitor the trademark register and related marks which are confusingly similar, which conflict with your mark. Be prepared to oppose them. If you're finding real big problems with infringements, investigate to gather intelligence, given how sophisticated all the networks are these days. And then be clear on your objectives and budget. And I do appreciate that, no one has infinite, endless budgets to spend on legal fees in China. So perhaps set out a few objectives. Do I just want to stop this infringer? Or do I want to make an example of this infringer? Or do I want to send a message out to the wider public? In which case, you can kind of mix and match your toolbox of options, be it sending a warning letter, doing more administrative action, thinking about, civil or even criminal action, especially if you deal in the areas, whereby there could be health risks to the public, such as pharmaceuticals. So, again, I appreciate that not everyone has the budget to do everything, but at least be clear on what your objectives are and how much you want to spend, and invest some effort and time and expense into, protecting your brand. next point is record your IP rights. If you are manufacturing products here, or selling products here, it's very important to record your registered trademark rights to the China Customs. I think China Customs actually really quite helpful. They are about one of the only custom authorities in the world which actually randomly inspects the containers that actually leave the country, and they look out for infringement. I think government is well aware that almost all the infringing products in the world originate from China, and so they do spend at least some time checking the shipments that go out. So if you have your trademarks recorded with China Customs, they would actually look, and if they spot any products going out of China bearing your trademarks, they would call your attorneys to let them know about it.
Rachel, can I interject here?
Sure.
Yeah, actually on our presentation we have a member of a former customs officer who actually explains how to record your customs with China, record your trademarks with China Customs. You can see that on stopfakes.gov, and it is entitled excuse me, I'm wrong. It is February 9, 2009, Recording Your IP Rights with Customs. It's on stopfakes.gov.
Okay, that's really helpful. I'll go look at it myself. And another point about recordation is also to record your trademark rights and other IP rights, like licenses, with the relevant authorities. Now, this may not be needed in all circumstances, but certainly if you're trying to expatriate profits from the country, you have to look into whether you need to record your IP licenses. And in the last of my top 10 tips, just quickly mention about other IP rights. So mainly I've been talking about trademarks, but also, for a lot of companies, you do have other IP rights that really should be looked at. Clearly, patents is very important. And by patents is, again, a very different concept of patents from that you have in the U.S. I think in the U.S. most patents are invention patents, but in China you have invention patents, you have utility models, and then you have designs. And designs could actually be a novel patination of a product. So those kind of patents would be quite helpful to companies who do very unique packaging and designs which may not be able to get them registered as trademarks, but could get registered as designs. And in China, they hardly have any substantive examination for this. So if you have, new fabric designs or things like that, it's really worth thinking about whether you can register a design patent. Another thing which a lot of companies do actually forget is to register the key domains. In China, the two most widely used domain suffixes are .com.cn and .cn. And the slight hitch is that currently, because of the number of, again, bad faith domain name filings, that the registrar has actually said that to file .com.cn and .cn names, this has to be done through a Chinese entity. So hopefully, if you have a Chinese subsidiary, it should be done in that name. Otherwise, a lot of attorneys actually use their companies to register these domain names and hold it in trust for the client until hopefully this regulation changes. So again, don't forget the .com.cn, because likewise, there are a lot of pirates out there who rush to register these domain names and try and sell it back to you. And last was what I mentioned earlier, copyright. There are copyright laws in this country. China is a member of the Berne Convention. But again, copyright, unfortunately, is rather a weak protection in China. So you can record your copyright like you can do in the U.S. Again, there's no real substantive amendment, and you get a copyright certificate. It may be helpful to waive at some people, but again, it's not the strongest of rights. And finally, just like to close off with just some other general tips, which is really useful for anyone doing business in China, is to conduct due diligence with your partners. Try to have really clear and comprehensive contracts, because again, we're a civil law country. There's no common law case precedents about how a contractual terms should be interpreted. So try to make your contract as clear as possible. Something that also helps is to have a very clear supply chains. We have some clients whose goods keep on getting stopped at customs, even though they're legitimate. It's just because they can't actually keep track of their supply chains in China. They kind of give instructions to one OEM, and he subcontracts to a lot of people, and they might all be legitimate, but then the client doesn't really know what's going on. So it's really useful again to keep a clear supply chain. So just to round off, my talk, I like to say that there are laws in China, but you have to use them. So you need to be diligent. And going back to what I would say, my top one tip is to file. A few $100s can save you a lot of money in the long run, because once your rights fall in the hands of a trademark pirate, it's time, effort, and years just to get it back. And if you don't actually have any prior usage in China, you're going to find it a real struggle under the current law to get your trademark right back. Point number 2 is help the authorities help you. Get all your documents in place so that the authorities can't have any reason not to help you. Get your registrations in place. Get all your power of attorneys signed. Get any documents needed properly notarized and legalized. And then you find that will really assist in helping you, enforce your brands. Finally, there are the courts. I'm sure most of us don't want to be there. The courts are not the kind of courts, I guess, we're used to seeing them operating in Europe or in the U.S., but they are becoming increasingly competent, and certainly in the country, in the jurisdictions like Beijing and Shanghai, especially Shanghai is called, you find that they really are very brand aware, and they really do help to try and fight for the rights of brand owners. So increasingly, I think the courts are really becoming much, much more IP aware and much more competent. Okay, so that's really just the end of my talk. It's just a rough overview of trademark protection in China. I'm really happy to take any questions from the audience now.
Again, to ask a question, to press star, then 1. Mr. Hayes, your line is open.
Hi, Rachel. I have a question. If you register your Chinese character trademark, are you covered both with traditional characters and simplified characters?
Absolutely, absolutely. China uses the simplified system, and it's Hong Kong that uses the traditional. But because it's actually the same word being simplified, so if you file the simplified version, you actually be able to use that against a traditional later mark.
And I guess a related question is, what about character order? Obviously, most of the time things are read from left to right, but under certain circumstances, reading order might change. Does I guess the various permutations of character order, is that also protected?
Yeah. Generally, as you said, left to right would be, currently now how most people file their marks, and it should be able to protect you for, let's say, top down, which is traditionally how Chinese is being written. Now, back to front actually probably changes the meaning of the words, but generally speaking, if a later mark was your mark in reverse order, under the current laws, they still consider that to be confusingly similar.
Okay. And what about homonyms or maybe visually similar characters?
Okay. Homonyms are tricky. Visually similar, I think, is a very good point. I think for visually similar marks, now Chinese is quite a tricky language. It's tonal, it's visual, and I generally feel that based on the practice, visual resemblance, you have a higher chance of convincing the examiner and the court that the marks are confusing similar, especially if the characters are very close and they're written in a very stylized version. Recently, there was a case whereby the wording for the mark house, jia, and the word for xiang, which is an elephant, kind of look alike, but they sound quite different, and their meanings are very different. But they were used on packaging such that they really look very similar, same kind of products, and really same kind of packaging, and the courts actually found the marks to be confusingly similar. In terms of homonyms, that's really tricky. I really find it very tricky, actually, to explain this. Certain homonym sounds could arguably be called similar, but if they're visually are very different and the concepts behind them are very different, they are unlikely to be considered similar. I hope that makes sense.
Yeah, no, that does.
Okay.
Thank you.
You're welcome.
There are no further questions at this time.
Rachel, this is Janice. We have some clients that come in and they don't yet do business in China. Maybe they just went to a trade show here in the United States and then somebody ripped off their mark. What kind of advice would you give somebody like that? Ripped off their mark and trying to register their mark.
Okay. I think as I mentioned, Janice, the best thing to do is, if China at all is important to you, just get in there and file as quickly as you can. If someone has ripped off your mark, there are provisions in the law that actually help you to cancel the mark, but these are pretty difficult to satisfy under the current law. The current law will require the legitimate brand owner to actually have had some prior use in China, such that there would be some form of reputation, and then it would then have to prove that the other party has actually ripped off your mark in bad faith. So it's kind of a two-limb approach, and I think many legitimate brand owners can prove the bad faith point, but they can't actually prove that they have a reputation unless they're really one of those really famous brands. I think gradually the examiners are trying their hardest when they know it's a clear case of bad faith to help the legitimate brand owner, but the truth is that trademark rights are territorial, and a lot of brands, people could have the same brands many places around the world, and unfortunately, if you have no prior use in China, it is pretty difficult to cancel a later mark. So hopefully the law will change, because there are current discussions to strengthen these bad faith provisions, but right now we don't have any news about when the new laws will come into force.
So even if you're not doing business in China, a pirate could still hurt you.
Yeah, absolutely. And if you then wanted to come in, you would then have to deal with this pirate. I guess also, hopefully another way, if you can sit it out for 3 years and the pirate hasn't actually used the mark, then you could cancel the mark. But what the nightmare scenario would be if the pirate actually decides to create his own brands, and we actually have seen this. Companies in China selling really pretty good-looking products, but why do they not create their own brand but try and stick someone else's brand in it? We don't know, but they do that. And we have had a few clients being caught in this situation when they then come to China to try and even just manufacture their goods, not even for the local market, but just for export purposes. And they run a risk that their, manufacturing these goods could infringe the registered mark in China. So even if you're just doing OEM business, it's something to be really, worry about.
Are there any other questions for Rachel? She actually she's quite involved in the Trademark Agents Association in China. They advise on the amendments to the trademark law, ways that they try to maintain the integrity of the register. She's any questions you have for her in that capacity, as well as in your capacity of your own business?
Again, to respond, press star, then 1.
Well, if there are no other questions, I'm going to close this webinar, but I wanted to let you know that Rachel has been so gracious to say that she would be happy to receive questions from people who are listening today. Maybe something else came to mind, or people who are listening to the audio recording on the stopfakes.gov website. Rachel can be reached at rtan@iprights.com. She said she'd be happy to take questions. You can also you can listen to her presentation and other presentations on the stopfakes.gov website. I also want to remind people that we have another webinar, 2 mini webinars, in fact, this Friday, March 18th. One will be at 10 a.m. and then Eastern, and the second will be following at a separate dial-in number at 10:30 a.m. They are on domain names and enterprise names in China, and those are both closely connected to your trademark rights. So as Rachel had told you, file, file, file. After you've filed, perhaps some of the rights that you have received by filing will be helpful in dealing with these 2 other issues. So March 18th. Are there any other questions for Rachel?
There are no further questions, ma'am.
Okay. Well, thank you very much, and we'll talk to you, everybody, on March 18th.
Okay. Thank you, everyone, and have a wonderful day. Bye-bye.